Shifting focus to an important story that is developing from the Supreme Court of India. It's a big day in the faith versus law debate. A 9-judge constitution bench of the Apex Court headed by Chief Justice of India Bobde has started hearing a batch of pleas on the entry of women and girls in places of worship across all religions. The bench has clarified that it's not hearing the review petitions revolving around the Sabrimala verdict, but the questions referred in the review order passed on the 14th of November. The bench is hearing on broader questions which are likely to arise in pending cases relating to right of women to enter mosques and Parsi temples. The Supreme Court is also going to further limit time for lawyers to argue in the matter to avoid any sort of an unnecessary overlap. Well, there's an update from the Supreme Court. The 9-judge bench assembling on faith versus law debate. The Chief Justice of India clarifying it isn't hearing the Sabrimala review, but is going to take up the points of reference relating to rights to pray and religion. So that's the update that we're getting from the Supreme Court of India. The court is also going to be limiting to time for lawyers to argue. We don't want unnecessary overlap. Anusha Soni is getting us more details on that. Anusha, it's important to clarify that the larger issue before the Supreme Court of India today is on two fundamental points. On the balance that one should really be striking between rights, particularly in this case rights of women, because most cases have got to do with women, versus religion, and how far really can the Apex Court or other courts also intervene in matters of faith?
Absolutely, Sneha. You know, at the outset, one must understand that in a country like India, law and religion has always had a problematic relationship. At a time when the Constitution of India is a progressive document and continues to be striving to so, going forward, a lot of religious practices, which a certain section of a religion may argue are essential religious practices, can they stand the test of the fundamental rights? Now, this is a question that the Supreme Court has been looking at, or perhaps trying to avoid, ever since the Triple Talaq legislation or the Triple Talaq case had earlier come to the Supreme Court, when the practice was declared null and void. Even that time a question was raised, what happens in cases where fundamental rights is in conflict with religious practices or vice versa? Today what the Supreme Court 9-judge bench is doing is monumental in many ways. If the earlier 9-judge bench had settled questions of privacy in our country, this 9-judge bench is not per se going to decide Sabrimala or the issue of entry of women in Dargah or Parsi. Subsequently, these cases may be decided. But the problematic and the troublesome relationship between the law and religion, that is going to be defined in many ways. The courts will know what approach to take, and there is likely to be a consistency that may come.
Yes.
Very briefly about the hearing, what Utkarsh tells us is that the Chief Justice of India has limited the time for the lawyers and the issues are going to be fine-tuned. Sneha.
You know, Anusha, there are many cases pending before the court, some of which the court has decided on, for example, like Triple Talaq. Just take our viewers through the details of other similar cases that are before the Supreme Court of India concerning, on one hand, religion and the kind of balance that the court has had to strike between rights of women in many of these cases.
You know, Sneha, when about 2 years ago the Triple Talaq legislation, the Triple Talaq practice, was challenged here at the Supreme Court. There was a PIL that was filed. The court gave a judgment and said, you know, the practice is null and void. The government brought in a legislation. Now that legislation is challenged before the court. That challenge of a legislation is very different from what we are seeing right now, because that legislation will be tested on certain basic legal principles. So that aside, the question here is, if there is a religious practice that interferes with my right to equality as a woman, as a member of a certain community, or a certain sect within a religion, how much is law going to uphold my right? If a certain religion forbids women from entering one temple, can the law really enforce it? Because it's my fundamental right to life and to pray in a temple. To what extent court can interfere in it? That has been the classic debate that has been panning out in this country, and there is much hope from the Supreme Court that the interplay between Article 14 14 right to equality, Article 25-26 that grants protection to minorities and denominations. What is the way that the court takes? Because historically speaking, Sneha, you know, all the judgments ever since the 60s, 70s, in the 21st century, the judgments have been conflicted. The approach has been piecemeal approach from the courts. Now, the yearn from the court is to have some amount of consistency with so many legislations and challenges coming before the Supreme Court.
All right, all writ petitions. Meanwhile, the court has clarified relating to Islam Parsi temples. Remember, entry of women at the fire temples as far as Parsis, the religion, is considered. Dawoodi Bohra community is going to be listed along with Sabrimala review cases on the next date of hearing. That is something the court has already said. Joining us here in the studio, Deshratan Nigam is a lawyer and Brinda Adige is a social activist. I'm going to come to you first. Brinda Adige, what is your expectation from the Supreme Court of India today, given the fact that so many issues which at the face of it appear to be, trying very hard to strike a balance really between rights and religion and rights of women particularly. The court has had to deal with many such issues, some of them that I just briefly mentioned. It's not black and white particularly. It's an important decision and it's a complicated one really before the court today, isn't it?
Absolutely. I am hoping that the Supreme Court would look at this entire matter of faith and right together. We know that religions across the world and in India are very patriarchal in nature. And if you look at some of the customs and practices, they have oppressed and continue to subjugate women. And like you mentioned, which God in any religion would agree to genital mutilation of children? Why would any God just say that, treat these children of mine who are women differently from those who are men? And I think these interpretations have to be looked into and challenged from the point of view of constitutional rights of all citizens, irrespective of their biology.
Right. And it's important, Deshratan Nigam, that the matter before the court today is not about Sabrimala alone. Like Brinda Adige also mentioned, there are other issues that the court has looked into. For example, a law like triple talaq and other important issues like female, genital mutilation. These are important issues before the court.
See, let me tell you, Sabrimala, they are not hearing. They have made it very clear.
Yes.
They have gone into larger principles.
Yes, yes.
What is the essential practices of a religion and what are the secular practices? So what they are saying, if it is, since there are conflict between the earlier two cases, Shirur Mutt case and the Dargah Committee case, Ajmer Dargah Committee case, because of the apparent conflict, so they constituted this larger bench of 9 judges. They could have constituted 7 judges, but there was already an earlier matter. I told you about the Shirur Mutt case, which was a 7 judges. Therefore, they deliberately constituted 9 bench judges.
And this 9 judge bench doesn't have anybody who's ruled on Sabrimala.
Yes, they are not, because there could be an apparent bias on other issues, because they are not hearing Sabrimala review. They are hearing a very larger question. So what is very important out here is, even in triple talaq, if you notice, they had to go to Islamic theology to say that it is unconstitutional. One, they could have easily, I am telling you as a critic of the judgment, they could have easily gone on gender discrimination and right to equality. One need not go to Islamic theology for that. But once you go to Islamic theology, which means the judgments is being pronounced on the basis of religious beliefs. If you have to keep constitution in the center, then one must not go into theology.
Okay.
That's one very important point that they have to look into. And then they have to segregate what are the essential practices of a religion. Now, Hinduism, Supreme Court says, is not a religion, it's a way of life, Justice Gajendra Gatkar in 1966 laid down, which was followed by Justice Verma also in 90s. And therefore, to compare something which you don't hold a religion to the other two religions or other religions which are based on books, very codified, that is also a very complex question. Because how can you frame, in Sabrimala, therefore I have always said, how can you frame a question whether the practices in Sabrimala is essential part of a Hindu religion, where you on the other hand hold that Hinduism is not even a religion at all. So there is an apparent contradiction there also. So these are certain, this is not a very simple matter, let me tell you. To segregate what is secular or superstitious beliefs from essential practices, would be a very complex issue.
Okay. So in that case, you know what, from what Deshwita Nigam is saying, Brinda Adige, you know, then it would be a fair presumption really that the court is once again going to be, you know, forced to go into theology when it comes to the issue of Sabrimala at least. Of course, the court has clearly said these aren't issues that we're looking at today. We're going to look at them at a later stage. This has got to do with the larger issue of rights of women and what the practices for hundreds and hundreds of years has been as far as tradition is concerned.
Yes, absolutely right. Theology might come into discussions and arguments, but let us again remember, whatever the theology that we may talk of, whatever the written codes and interpretations are there, it is largely from a patriarchal point of view, and it has never been a woman's point of view. Whether you take the Bible or the Quran, or for that matter any other religious text or the codified text that we talk about. So right now when we are talking about right to pray, we are looking at an issue where women never raised their voice 100 years ago or 1000 years ago, or probably they raised it and it was, you know, sidelined. Today it is not going to be like that. Yes. We have a large number of women who consider that these practices are discriminatory.
Yes.
So when you get into theology, the first question would be, would God really want to discriminate against his or her children simply because one is a man, one is a woman, or one was born in some so-called caste? That becomes a pertinent point with relation to our constitution.
All right. So all of the
let me just
petitions.
add something here.
A quick reaction, please. Yes.
You know, you have to see the India's history and civilization as well. In last 1000 years, because of the invasions, what changes took place in the society? Like sati was never a part of, you know, the system. It had become an integral part, but then it was banned. The parda system that came into system, we didn't have. Look at the temples, the architecture that we have, and the kind of clothes that the women wore. So the courts must go into this historical aspect, how these practices came into the system, and this discrimination which was not supposed to be there, which was actually not there earlier if you go about 1000 or 2000 years back. So I think even if some historians need to be also involved in such cases.
Okay, all right. The court has begun to hear that petition that's going on in the Supreme Court of India. Anusha is also with us. She's at the Supreme Court. Utkarsh Anand, our legal editor, is getting us those details of what the court is saying. In fact, for the moment, it's time for a quick break here. I'm going to thank my guest here and also thank my colleagues Utkarsh and Anusha for those quick updates from the Supreme Court of India. That, of course, continues to be a top focus story throughout the day right here on CNN News 18. It's time for a quick break. News continues in just a bit.